Good afternoon, everyone. I hope everyone is doing well. So we're going to run through a number of issues today. We're going to start with the family law, and then we're going to go on to the bankruptcy. So right now the courts are closed for live in-person hearings except for emergency matters, but they're still accepting filings. So the Virginia Supreme Court issued yet another order yesterday where they reset some rules, and one thing buried in here is that the courts are allowed to have in-person hearings effective May 18th, which is interesting because the governor's stay-at-home order is still in effect until June 10th. But I know Alexandria, where we're located, has already announced that they are not having in-person hearings until June 12th or 13th. So the first question, though, before you get to the hearing, because effectively right now you can't have a hearing unless it's an emergency, and I'll speak to that a little bit later on, is should you still file for divorce or file for support or custody, whatever your needs are? So the short answer is yes. The longer answer is, first of all, you still have to have grounds for divorce or grounds to file for custody or support or whatever it is you're looking for. And the reasons to file or not file from before COVID are still in existence. You know, is it a good litigation strategy? Is it better to come to agreement before you file? The answer to that question is almost always yes. And then the COVID implication of it is, if everybody's still in the same house and can't move, do you even have grounds for divorce? And of course, that's a complicated question. The perception out there is that you can't move, but people are moving. They are going to different places. That doesn't per se violate the governor's order because you're transitioning to another home. And quite frankly, I see lots of moving trucks out there. It's kind of surprising, but people are moving out and establishing other residences now. But mechanically, you still can file for divorce if you meet the requirements. You can still file for custody and support in the juvenile court. And we have on there, file now to reserve your place in line, and when you file can affect when your case will be heard. So what's happening, I mean, whenever you file, kind of reserves your place in line. And let's use Alexandria as an example. So without COVID, you file a divorce in Alexandria, you can pick a final hearing date on your own, but if not, the court will notice you for a status conference 4 months down the road, at which point they will want you to pick a final hearing date. Alexandria in particular, before COVID, wanted cases all heard within 1 year. So they're very proactive about status conference dates. Fairfax does it too. It's a longer system in Fairfax. Arlington has started doing it. Loudoun, everybody goes to every Monday to scheduling conference in Loudoun. And Prince William has its own system. They don't really notice you for status conference that I'm aware of. I don't actually file that much in Prince William Circuit Court. So when you file, is you can only get a hearing date once you file. So you need to file in order to get in line to get a hearing date. And then you can also put a normal times motion on the docket to actually pick a hearing date. You don't have to wait for the status conference. What's happening now is that everything that's getting filed is getting pushed out. All the cases from when the courts basically shut down in March through May, or Alexandria now through June, all of those hearings have to get rescheduled. If they haven't been rescheduled directly by counsel calling the court, they're all put on a July 13th status conference date, which is status conference is the day you pick a hearing date. And this morning, because I talked to the court this morning, the July 13th status conference date is completely full, and they have pushed it all out to August 20th for a status conference date. So the longer you wait, the further out you'll get a status conference, and we don't even know if they're opening up for motions day or what that's going to look like. So that's what the idea of reserve your place in line. So if you filed today, you probably wouldn't get a status conference, a date to pick a final hearing date, until the fall, and then you're not going to get a hearing date until next year. Now, you may not be eligible for a final hearing until next year, but if per chance you already have your 1 year separation or your grounds for divorce met, it is unlikely if you file from this point in time forward that you're going to have a contested multi-day hearing heard this year, because cases already were scheduled through the fall. I had a case already scheduled in November that got picked last year. And now 3 months essentially worth of cases are getting rescheduled. So when I've talked to the court administrators, the response I get is that the cases that are already set for after all the emergency expires are still going to take place. The ones that were continued are going to be squeezed in on top of those. So it's kind of like when your flight gets canceled. It's not like they cancel everybody else's flight to let you have priority. You have to get squeezed in. I will tell you, for example, I had a 2-day hearing set this week in Alexandria that has to be heard before school opens up again, normal school, because it's a relocation custody case. My client needs to move. And it was set for 2 days. We managed to squeak it down to 1 day. We got an August date, which is great. We asked the court, what would a 2-day hearing be if we needed that? She said December 21st. So that's a problem. If you have a hearing that's going to be set for more than 1 day, you're not going to get it heard anytime soon. And kind of the longer you wait, the further out your trial will be. But of course, you still have to have grounds, and it still has to be an appropriate time to file for divorce. Okay, move to the next slide. So, mediation for family law issues, and then these next 2 slides are the types of issues that are probably involved. Mostly what's happening now with the COVID is that people are concerned about the custody schedules, the visitation schedules, and I'll talk about that in a bit. And then if there's a loss of income, it's child support and spousal support. And the real problem we're having now is that we can't get into court on these issues unless someone is, you know, absolutely starving and can prove that there's no money and the other parent has money, which is difficult to do, or there's an absolute refusal from one side to allow the other side to see the children despite a valid custody order. And it is specifically in the governor's order that people can travel for visitation schedules. So that's not a valid argument if a client tells you that. So one thing we've been offering is mediation. I am a mediator. Jessica Leischner in our office is also a mediator, to try to do essentially spot resolution of these things. We can still do full-blown mediation, mediate the whole case, but what's happening now is people need short issues resolved. So we've offered this mechanically. The way it's done is like this webinar. It's either done on Zoom or GoToMeetings or one of the other platforms, or by phone. So if you have issues or your clients have issues that they can't work out between themselves, and that the 2 lawyers, if you have it, can't work out, the same reason to send them to mediation still exists now. And besides us, there's a lot of mediators are still operating remotely. The retired judge mediation groups are operating remotely, but they don't handle people who are not represented by counsel. We do that because we are the direct mediator. And even if it's just, like I said, a small issue, like if one parent is concerned that the other parent isn't complying with the COVID requirements, or that there's other people in the home, how can we resolve that to try to get some money flowing on a short-term basis if there's been income reduction? Those are the kind of issues that are popping up right now. And now it's becoming loss of job and loss of health insurance. So if one parent, the parent who normally had the health insurance, no longer has a job, we already have a little bit of lead time for COBRA, but often it's cheaper for the parties if it switches to the other parent. Ooh, there's a question. Can I stop my child from going to his dad's house? I'm afraid he's been immunocompromised. Let me put a pin in that one. I'll get back to it. These are the other kinds of issues that are popping up now that may require short-term mediation if you can't work it out directly yourselves, or can't work it out through your counsel if you have them. So that's how mediation's being used now, always a good example. So let's go to the next slide. Okay, so like I said, the governor's order, the stay-at-home order, specifically exempts travel for custody and visitation. Let me answer the question that's on here. Can I stop my child from going to his dad's house? I'm afraid he's been immunocompromised. Now, I can't really tell, does this mean the father is or the child is? But the short answer is, can you just say, no, you can't send the child over legally? No. If you have a valid custody order in effect, you cannot simply not send the child over for visitation. How do you resolve it if you're concerned? We have suggestions, you know, talk to each other. Let's not just play the I'm not going to do anything, I'm not going to respond to you game. Get it in writing if you make an alternate arrangement. And if you have an emergency, file and seek an emergency ruling. Now, if the child has a compromised immune system and you don't want the child going back and forth because you're not sure of what's going on in each party's household, that's probably a legitimate thing to file an emergency motion to ask for a modification of the visitation arrangements during COVID. It's certainly worth filing and asking, because otherwise you're just going to be violating the court order. Now, right now, of course, while the other side could file what they call a rule to show cause to hold you in contempt of court if you refuse to turn the child over, that's not going to be heard now, but it will be heard when the courts open up, and the court can still inflict remedies for those situations. So most of the cases that I've seen, when there's a huge disagreement as to whether the kids go back and forth because the parents don't trust each other, if it's just a matter of I don't trust him, I don't think he or she is keeping the house clean, the courts have been rejecting hearing those as an emergency. If you've got a child or a parent with an actual medical condition, or you have a multi-generational household and you don't want the kids going back and forth when there are grandparents in the household, those are more likely to be heard. Now, the court's going to want you to resolve it. The resolution is fairly obvious. Limit the visitation, and then when things open up again, whoever missed the visitation should get more visitation time back. Normally that's an issue because the kids are in school. Well, they're not in school anymore. I mean, it's still the school year, and they still have to do remote learning as much as they're doing it in their various jurisdictions. But the normal concerns about, well, we don't want to flip them back and forth during the school year and where are they sleeping, kind of aren't in effect anymore. So there's, on one hand, there's more opportunity to have makeup time later once COVID restrictions lift, or once you're more comfortable going back and forth. That's the best thing to do, is to come to agreement. Now, if you can't come to agreement directly, you can't come to agreement through your counsel, like I said, you can try mediation with us or other entities that are doing it. A court is going to be concerned if a child is in danger or if parties are in danger. They're not going to be so concerned if it's just, well, I don't think she keeps his house clean enough. It's going to have to be something more particular to your case. The support matter, the emergency basis is kind of, again, if there's absolutely no money coming in. If that's the case, you should file, because a court cannot act on child support or custody or anything, actually, unless there's a filing in court. And on the flip side, if you're the one who's paying and you've lost your job, and it's going to be a loss of job for more than a few weeks, you have to file a motion to modify child support and spousal support if you pay it, and if it's modifiable, because the court cannot do anything to modify support without a motion filed. And even if it's not heard now, the courts can go back retroactive. If it's a modification, they have the ability. It's a may, not a shall. So they may go back and retroactively modify the support. If it's initial support, then they are supposed to go back and modify the support. So if you have someone who has lost a job and it's not going to come back, which is a little difficult to tell right now, then you should definitely file, even if you don't have a hearing now. Okay, a question came in. If I'm going through a divorce, can my husband have access to my stimulus check? Well, this is really a practical question, because the stimulus check is kind of an advance tax refund. It's not really property, it's a government program. So mechanically, what's happening with the stimulus checks is that they're either getting deposited in the bank account, usually for the 2018 tax return. If it's a joint account, then either one of you can have access to the money. If it's a paper check that comes in, made out jointly, you'd have to deposit it in a joint account and split it. So can your husband literally have access to it? If it comes into a joint bank account, he can. If you filed separately, you get a stimulus check in your own name, that's your money, and he can't access that. What can we do to help our children cope with missed visits? Well, what a lot of clients are doing who aren't sending the kids back and forth voluntarily is they do the Skype and the Facebook, and everything else. But what the children really need to know is what's happening, what's going on. If they're used to seeing the other parent, they're going to want to see the other parent. The kids, you know, everything is disrupted for the kids. There's no school, there's no friends, and children really need structure. You all parents know that. So depending on the age of the child, sit down and make a schedule for, you know, phone, other contact. You know, they can play outside if you don't want them going back and forth in the house, as long as you comply with all the social distancing, and you may or may not want to have them outside. It depends. But work with the other parent to make up a schedule for the missed visits so that everybody knows what's going on. That's the best way to handle it. And that's what therapists have been telling me that I've talked about. It's like they really need to know. Children get really concerned about practical matters when parents are going through divorce, odd practical matters. The Fairfax County that has you watch it, I think they changed the video now, but it used to be one where the therapist would say on the screen, the kids are most concerned with, you know, the parent who leaves. It's like, how are they going to eat dinner? Because usually they would eat dinner at home and the other parent would make dinner, and what was going to be in their refrigerator. So kids are concerned with smaller issues that you may not think they are concerned with. So concrete steps, let them know what's happening, let them know what can happen, know what you can do. If they're older, involve them in the scheduling, not the decision making, but the scheduling process. You don't want the kids to run the show, and you don't want them to think it's their responsibility. But if you all can cooperate with each other, that's the best way to do it. All right, one of the questions that has come up about the summer versus school year schedule, a lot of people have a different schedule for visitation and custody in the summer versus a school year. So when the schools all closed, there was some debate as to whether, so is this the summer? Well, it's March 13th. It's not the summer, but some people wanted to switch to the summer schedule. Usually when you have a difference between the school year and the custody schedule, you have parties that split the summer in half and they have week on, week off custody, or they have the weekends go longer because you're not worried about getting the kids to school. School year custody schedules, when there's a difference between the summer, basically have the children living more in one place during the school year. So this has been debated on a lot of the lawyer groups. And of course, there's no court case giving guidance because there's no court cases being heard on this. There is one in Southern Virginia that did say, I could correct myself on that, that no, it's still the school year. Whenever the school year would end normally is when the school year ends, between school year and summer custody. So somebody got in there on an emergency basis and got a judge to issue that in a Southern Virginia jurisdiction. So that's the prevailing wisdom, is that it's still a school year until the school would close normally and the kids are still doing distance learning. So technically they are still in school. Another issue that comes up is a lot of people send their kids to go visit the grandparents, you know, in Florida or Wisconsin or Michigan or Maine during the summer. And what are they going to do about that? Well, right now, I mean, the law is when you have custody of the child, you can do whatever activity you want with the child unless the child is endangered. So if it's your custodial time in the summer and you usually send them to grandma for a week in the summer, can you do that? Legally, you can, unless you're violating travel restrictions. But the idea is, do you want to do that? I mean, do you really want to send your kids to Florida now, where half the population is vulnerable to the COVID, at least? And, you know, Florida, my parents live in Florida, so I'm very worried about them there. Florida is really uneven in its enforcement of social distancing restrictions and beaches open and whatnot. And, you know, there's a lot of hot spots in other states too. So can you literally do it? Probably. If you're the other parent and you don't want the children traveling to a state without social distancing or going to where there's, you know, potential for more COVID exposure, you could try to file a motion. It depends, you know, when summer starts. Of course, maybe open by then, so you can file a normal motion or an emergency motion to prohibit the children from being taken out of state because of concerns about COVID. Right now, because Virginia has a stay-at-home order and travel is not permitted, my interpretation of that is that you cannot take pleasure travel with the children. And I think a judge would probably say, not right now, while the stay-at-home order is in effect. That's due to expire on June 10th. It may or may not be extended. kind of looking like it's going to be loosened up a little bit with still all social distancing rules. So then that will not be in effect anymore, which means you could take non-essential travel. If you're the one who wants to travel with the kids, I mean, you need to use some common sense. Do you really want to take the kids to an area with a lot of COVID and not a lot of great social distancing compliance? It's a tough decision to make, but that's another issue that this plague has arisen. And, you know, everyone is saying it's going to come back again in the fall with the flu season. So we're basically anticipating that there'll be another stay-at-home order in effect, and the schools will probably be shut down again for a portion of the fall and the winter. And hopefully they will have the long-distance learning set up better so that the kids can actually learn in school. So that's going to come, and you may want to consider referencing that in any agreements or court orders you have going forward as to what happens during a plague, essentially. You know, we always learn from these things as to include what comes in there next. And what you could simply do is state that we're still going to have the custody in effect if there is a shutdown due to health concerns, or if you want an alternative arrangement, put the alternate arrangement in the court order agreement so that it will kick in automatically. If school shuts down again and you have a custody schedule where the kids go back and forth during the week, during the school year, the issue has arisen, I've seen, where, well, what time does the school end? It says the end of the school day. School day is ending at 1:20 because that's when distance learning is ending. But no, the kids are really supposed to stay in school and do their homework, their at-home work, until the normal bell schedule. So typically the answer has been it's the normal bell schedule. When school releases, when it switches custody back and forth. But that's another issue to address going forward. You know, every time we have one of these natural or international disasters, things change. After 9/11, you know, we had to have a lot more requirements in the travel section and catastrophic clauses going forward. I think everybody's custody agreement, court order, is going to have some terms addressing this because it's going to happen again. I keep looking at my clock. That's why I keep turning around. I don't want to cut into Xue's time. Back to the support one. If it's a short-term drop in income and your income comes back up, financially, it's not going to be worth it to try to change a child support. If it's a loss of income for a month or two, and then you resume the same income, it's an average income basis for the court, it's probably not going to be worth it. But if it's longer term, or if you're released from your job and they say, we're not opening the business again and we have no idea, it's probably worth it to file because you don't know what's going to be happening with that. And if it's a longer term issue, then that needs to be dealt with. I'm looking to see any other questions. No other questions. All right. I think I'm done with my part. So let's probably switch over to bankruptcy on that same note about loss of income.
Okay, thank you, Carolyn. As Mark said, my name is Xue Connelly. I'm a bankruptcy associate here at Xue Grimes. So I'm here to talk to you a little bit about bankruptcy. And with the COVID-19 pandemic and the massive loss of jobs that we've seen in the last couple of months, it has been a growing concern for people on what they can do to minimize the financial damage that your loss of job has caused or created in your family. So one thing I want to emphasize at first is that you need to focus on paying your essential bills first. So for those with a limited income or who have been laid off due to COVID, that means prioritizing your essentials, your utilities, your car payment, your mortgage, or your rent payments. And the reason for that is because although right now the governor has stopped evictions aren't being processed because the courts are closed, and because of the governor's order, evictions aren't being processed and foreclosures aren't happening. At the end of this period, you're going to get this huge balloon payment that's going to come due, either to your landlord or to your mortgage company. So if you can pay that, you should try and prioritize that. Your utilities as well and your car payments, because at the end of the day, you want to be able to have transportation, have electricity, have access to the internet, and have a home. The non-essentials or credit card payments, any creditors that are coming in. Now, creditors, as you have probably seen in the news, creditors haven't stopped trying to collect. With the courts closed, that means that no judgments or lawsuits are being processed right now. There's no hearings and there's no garnishments being processed. However, that doesn't stop the phone calls or the letters or the email reminders or any of those things that add stress to an already stressful time in your life. However, you need to understand that while they can still do that, as of right now, the first thing you need to focus on is making sure that you have access to the essentials and have everything that you need for your family. So right now, if that doesn't help, if focusing on your essentials and waiting for this to come, waiting for all of us to get through this that we're in right now doesn't help, bankruptcy can help relieve the financial stress that you're feeling. If this is a temporary job loss, or if this is looking to be a more permanent job loss, the majority of Americans, unfortunately, don't have the savings required to get through something like this financially. That is what bankruptcy is here for. Bankruptcy is a federal program. It's a federal court system, and the purpose of it is to give relief to individuals who can no longer maintain their financial obligations, and it's something perfectly normal to do in that situation. So one of the best things about bankruptcy, I think, is that once you've filed for bankruptcy, creditors can no longer try and get you to pay. A bankruptcy court initiates an automatic stay. Which stops all creditors from coming after you, which means all legal actions are stopped by the filing for bankruptcy. All calls, all emails, all letters that you're getting are going to be stopped the moment that we file. And so that is something that gives everyone immediate relief. I have a question here. How do I know if I should file for bankruptcy now or wait? Well, that question is really more of a personal question for your case. Basically, if you can't handle your credit card bills or your creditor's bills, it's probably best for you to speak to an attorney about obtaining bankruptcy relief. If you think that this is a temporary job loss and you're expecting to be going back to work soon, and you can maintain your lifestyle for right now, then it may be that you can take a couple weeks to figure that out. However, I think you should speak to either me or my colleague, Greg Wade, or another bankruptcy attorney to see if this is the right time. One of the good things about the bankruptcy court, and I think it's the next slide, is that we can file for it remotely. So if you think that this is a time for you to file bankruptcy, then it's important for you to speak to a bankruptcy attorney that can guide you in what best way to go. Timing is very important for bankruptcies. Timing in regards to if you own a home, or if you're looking at a judgment, or if you want to relieve some of the stress. Your health, your mental health is very important in this situation as well. So it's important for you to look at all of your options, talk to a professional about your specific case, and then make that decision as you go. Next slide, please.
Xue?
Yeah.
So one thing, the automatic stay in bankruptcy also applies to divorces. So if you have a divorce case filed and one of the parties files bankruptcy, it stops the divorce case, not the custody part, but it stops all the financial parts of it too.
Yes, that's very true. So once the stay is in effect, there are ways for you to get the bankruptcy court's permission to continue the case. But for equitable distribution or looking at the division of finances, the bankruptcy court generally doesn't allow you to continue with separation of assets until they've determined the bankruptcy case. So what not to do if you're in financial distress right now? Don't use your 401k to pay for credit card debt or pay off or medical debt or anything. If your 401k and your retirement benefits are incredibly important for your financial future, and they're exempt in Virginia, the entirety of your retirement assets are exempt from creditors in terms of bankruptcy. So what you're basically doing by taking your 401k to try and pay off your credit card debt is you're borrowing from yourself, and you're taking an asset that is protected by the bankruptcy court pay off a debt that you have other means to get relief from. Will I, we have one more question. Will I lose my COVID-19 stimulus check if you file for bankruptcy? So if you file for bankruptcy, the bankruptcy trustee looks at all of your income, including your COVID-19 stimulus check and your tax refund if you get it. However, a bankruptcy, when the bankruptcy petition is filed, it takes a snapshot. So it varies on when you've received the stimulus check, if you've already used it for living expenses, or on top of that, the bankruptcy court gives you exemptions. So when you file for bankruptcy, they don't want to, the exemptions are there to be able to get you started on a financial future. So if you use one of your exemptions to protect your COVID-19 stimulus check or any money you have in your bank accounts, then that would be protected from the bankruptcy court and the creditors. And next on our list of notes is don't spend any money on anything non-essential. So that is basically, you know, don't, like I said, don't use, if you're on a limited income, don't use your money to pay off your credit card debt or to make your payments. And it's kind of backwards to think about it because we're all taught that we need to make sure that all of our bills are paid on time. But in situations like this, it's important to try and make sure that your family's taken care of, you are taken care of, and that the credit card companies can wait, or we can look at bankruptcy to get them discharged. Don't ignore the payments you can't make, and don't avoid seeking help. Like I said, in bankruptcy, timing is very important. So come seek help as soon as you can. We're here to help. We're here to make sure that we can find a strategy that works for you, that works best for what you need to accomplish. And so we have seen a lot of people come in and they are, you know, facing a foreclosure in a couple weeks, and they've just been ignoring the problem because it's stressful. It's really hard to look at. You know, nobody likes having to think about these unpleasant topics, but try and seek help as soon as possible, because the more proactive you are, the bigger relief you're going to feel. Next slide, please. So, should you file for a Chapter 7 or a Chapter 13 bankruptcy? So, the Chapter 7 bankruptcy is the one that most people know. It's a debt forgiveness plan. And what that means is that the bankruptcy court looks at your assets and looks at your debts, and any unprotected assets are used to pay off your debts, but at the end of the day, you walk away from your debts, from any debts that are unpaid or paid a percentage of. And it typically lasts between 4 to 6 months. A Chapter 13 bankruptcy is different in that it is both a debt forgiveness and a debt repayment plan. So this one lasts longer. It lasts somewhere between 3 to 5 years, and it allows you to pay back a portion of your credit card debt in exchange for a discharge of everything else. And it also allows you to pay back an arrearage on your mortgage for you to be able to stay in your house to avoid a foreclosure. And it allows you to, it's a little bit more flexible than a Chapter 7. However, if you do not have an income at this moment, you need to have an income in order to be eligible to file for a Chapter 7, for a Chapter 13 bankruptcy. And whether or not you qualify for a Chapter 7 or a Chapter 13 is very individualized. But right now, to keep in mind, a Chapter 7 means that you will walk away. It's 4 to 6 weeks, and that you don't have an income and can't make a payment plan work. I have a question, and it's what happens to a Chapter 13 in divorce. So as Carolyn mentioned previously, once you filed a bankruptcy, that stops all divorce proceedings. So for a Chapter 13, if you filed a joint Chapter 13 with your spouse and now you want to file for divorce, it complicates the Chapter 13. The Chapter 13 would either be dismissed by the debtor. A debtor can voluntarily dismiss a Chapter 13 so that you can get divorced, and then that individual can file an individual Chapter 13. Or if the parties are still married, they can file what's called a separate household income plan and expense sheet, and you can base your Chapter 13 payment on keeping separate households during the course of your separation before your divorce is finalized. Once your divorce is finalized, you cannot file a joint Chapter 13 because you're no longer married.
Wait.
Yep.
I want to ask you a follow-on question about that, and also someone else asked me a question here. For some reason, I can't type the answer in, so let me answer that first.
Sure.
I mean, when do you anticipate uncontested cases will be heard based on the backlog of cases in the pipeline? This is probably for Alexandria. Howard, how you doing? Right now, I mean, the courts are still signing orders, so if you're going to send in an uncontested divorce on affidavit and a final decree, they should be catching up pretty quickly. They're not going to be setting Ori tennis hearings if you want to do the cases before the court, probably until July. Court administrator told me she's not setting anything in June. Okay, so now back to the chapter 13. Xue, can you speak to the interplay thing? Welcome, Howard. Between, you may be doing this later on. If you are, just tell me that. What's dischargeable and what's not in a 7 or a 13, if there's a difference for divorce, you know, child support, spousal support, the property division, and the debt. Who's supposed to pay the debt? That's always a critical issue. Thank you.
Sure, yeah, I can definitely talk about that. So a chapter 7 is no spousal support, no child support, mostly no taxes, and mostly no student loans are dischargeable. As to the marital debt, that depends on how the property settlement agreement is drafted and whether one party who took on that debt took that on in lieu of support. If it is a debt that is taken in lieu of support, then that is generally non-dischargeable. Those cases tend to be more contested, but it's generally non-dischargeable. For a Chapter 13 bankruptcy, a Chapter 13 bankruptcy has something that's called a super discharge provision. And what that means is that the fact that you're in a 5-year plan gives you a little bit more flexibility on paying back your arrearage of child support or spousal support through the plan. And if you're paying it through the plan, that stops the enforcement action in the state court. It also allows you to pay any equitable distribution awards that can be pay a percentage of the equitable distribution awards and then have that discharged at the end of the Chapter 13, as long as they're not considered to be in lieu of support. So the question always ends up being, and it tends to always be litigated, is if you have, you know, a business and somebody and you owe your ex-spouse a percentage of a payment because you kept the business, is that equitable? Is that an equitable distribution, or is it in lieu of support? If it's equitable distribution under a Chapter 13 bankruptcy, and the court finds it that way, then it can be, you can pay it back as an unsecured claim, and you can pay her anywhere from 1 to 100% through the 3 to 5 year plan, and whatever doesn't get paid gets discharged because it's distribution, and it can be discharged under the super discharge provision of a Chapter 13. If it's in lieu of support, then it cannot be discharged, and it has to be paid back in full, whatever arrearage it is, by the end of the 3 to 5 year plan.
So, Xue, what if somebody, it's kind of weird, gets a monetary order, just says, you know, spouse has to pay the other spouse X amount of money, and the one who's paying is just, you know, files bankruptcy before he pays the X amount of money, and you don't have the clause in your agreement, or because you don't get it in a court order, if a judge orders it, they never order this is in lieu of support.
Mm-hmm.
You don't get bankruptcy protection that way if a judge decides your equitable distribution in that regard. So what if they file bankruptcy and say, I'm not going to pay you the $10,000 I owe you to equalize our assets, and there's no clause that says this is paid in lieu of support. To the contrary, it says this is a payment to equalize our assets. Is that going to be discharged or not? What do you think?
So it will not be discharged in a Chapter 7. It can't be discharged in a Chapter 7. In a Chapter 13 bankruptcy, it would typically fall onto the bankruptcy judge to determine whether that's in lieu of support or whether it's an equitable distribution claim. And, you know, there'll be a hearing on it. There'll be an evidentiary hearing on it, just like in state court. And once that's determined, then either the spouse who's owed the $10,000 will get a percentage based on the plan, or she'll get 100% because it's considered in lieu of support.
Okay.
So it depends. It varies on the Chapter 7 and a 13, but in a Chapter 7 bankruptcy, any equitable distribution order is non-dischargeable. They have it in the code that they cannot get it discharged under a Chapter 7. Under a Chapter 13, they have a little bit more flexibility. All right, next slide, please. All right, so bankruptcy is filed electronically. Most courts in Virginia are scrambling to set up their electronic system to file things. The bankruptcy court is a federal court, and they have had an electronic filing system for as long as I've dealt with them. So it's a very easy system to use. We can meet with you over Zoom or Skype instead of in person. Right now, we're not meeting with clients in person. And the bankruptcy court has allowed us to have some flexibility on the requirements to file electronically. So we can file at any time during the day. We can file an emergency petition, which is just the bare bones petition to get you that stay, to stop all lawsuits, to stop all creditors without getting all of the information ready. And then we have the ability to supplement that emergency petition within 2 weeks of the filing. So we actually have a lot of flexibility in how we can strategize to get you the relief you need in the fastest way possible and in the best way possible for your situation. I have a couple more questions. No, those have already been answered. So the important thing to remember is that you have to look at your debts and think about whether or not if the COVID-19 situation has increased the chances of you having judgments put against you, having garnishments filed, you don't have enough money to pay for your food and your essentials and pay your credit card bills, then you need to talk to somebody that can look at bankruptcy as a means to help you immediately. And even regardless of the COVID-19 situation, it is important to understand that even though, like I said, we've been told our entire lives that you need to be on top of your bills, you need to pay your bills, bankruptcy is bad. Bankruptcy is a federal government program. It's our founding fathers in the Constitution gave Congress the power to make bankruptcy laws for this particular reason. It's for us as Americans and as U.S. citizens to be able to get the relief that we need in these kinds of cases. So there's something to be said about that. You have to, we have this program that can help you and can give you almost immediate relief to the stress and tension and worry of making your bills on time.
So with the time that we have left, unless somebody's got specific Q&As, Xue and I are going to talk about a COVID bankruptcy, divorce, disaster scenario, the thing you want to avoid. So let's say you're a small business owner and you have a mortgage on your house, you have rent on where your business is, you have little kids, and nothing is going well. So the marriage is falling apart, the business is falling apart, there's no money, there's a mortgage, there's lots of debt, and there's no money to be paid, but people still have to live. So on the divorce side of it, the question is, do you try to save the house or not? Are people going to move, is one party going to move out of the house with the kids or not? How long can we stay in the house until the bank forecloses on it? For the business side of it, and let's assume the courts are all open up at this point so people can take legal action against you. Is it better to file the divorce first and then do a bankruptcy, do a business bankruptcy, do a personal bankruptcy? Overall, you kind of need to coordinate this if you want to try to hold on to anything, but let's take the first step at a time. Let's talk about the house. House with a mortgage, don't have any money to pay the mortgage, need to have housing, and let's just say one of you has moved out and taken the kids to grandma's, but you still need to go back and forth. So Xue, in your opinion, if you've got a business that's shut down, it's not going to come back, should that person file bankruptcy 7 or 13 or bankruptcy at all to save the house and avoid the business debt? Should the divorce be filed first? What do you think?
It's a question of what you want to take care of first. The biggest question is, are there personal guarantees in the business for the business debt? So a lot of leases, a lot of SBA loans request personal guarantees. If you have a personal guarantee on your business debt and the business is going downhill and there's no way you're going to be able to recuperate it, a personal bankruptcy is going to be the best option because first of all, one thing that's important to note is that at Chapter 7 for business, the business doesn't get a discharge at the end. It just kind of liquidates and you pay back the creditors what you can, but the business itself still owes the money. A personal bankruptcy, you do get a discharge. So the first thing you need to know is a personal bankruptcy is important if you have any personal guarantees, because if you close down the business, they're going to start coming after you personally for the money that you owe. The important thing is that the other question Carolyn brought up is the house. So with the house, if you are looking to keep the house and you're a couple months behind, but you anticipate having income to pay it, the mortgage company saying you owe us the balance, you have to pay it immediately. Chapter 13 grants you the flexibility you need to make monthly payments on the arrearage and be able to keep the house. And so that's something that you may want to consider if that's what your primary goal is that a Chapter 13 gives you that ability. If you are looking at a Chapter 7 because you don't have income, a Chapter 7, while may not allow you to keep the house because you still have to end up paying the mortgage if you want to keep the house for forever, the Chapter 7 will slow down the foreclosure process. So what it does is it stops any actions that have started before the bankruptcy was filed, as soon as the bankruptcy is filed. Once the bankruptcy is filed, the bank will then have to go to court and get an order allowing them to no longer take into account the automatic stay to try and start foreclosure proceedings. So it buys you more time to kind of get everything organized and allows you to move past. And it also has you no longer personally liable for the mortgage. So when you have a mortgage, not only is the mortgage secured by the house, but if for some reason your mortgage is more than the house is valued, you're personally responsible for whatever that difference is. So if you sell the house at $200,000 and the mortgage is $300,000, they're going to come after you for that $100,000. But if you filed bankruptcy, that personal obligation has been discharged. As for what you should do first, a divorce or a bankruptcy, that's always a good question. If you're looking to do it, it depends on what that means for your income, what that means for your assets if you're looking to save the house through a Chapter 13, and what that means for whether or not you qualify for a Chapter 13 or a 7 if you're looking at a 2-income household versus a 1-income household. Some people want to file bankruptcy and discharge the debt before going through the divorce, and some people think that they should get divorced because one of them may not have as much debt and may not be in a position that needs to file bankruptcy and doesn't want to. The other important thing to keep in mind is that while you're married, you have the protection of holding a house by tenants by the entirety, which means that creditors of one person can't go after the house for the other, for the house if it's held that way. So you have some protections against creditors as a married couple that you wouldn't have if you were just an individual filing.
So that last point is important, especially in terms of the timing of the divorce or not, because either by agreement or court order, once you get divorced, you no longer hold property as tenants by the entirety. You hold it as tenants in common, and creditors can attack your individual shares. So sometimes you time the divorce and the bankruptcy when you've got a full-on disaster going on to either take advantage of that or to hold on to it. Because if you've got a small business that's gone under and you have a house and a business, you probably don't have a lot of retirement accounts, because that's often the case with small business owners. They put everything into the business and they're trying to save the house somehow. So if they continue to pay the mortgage payment and then file bankruptcy to discharge everything else, you've got to time the divorce carefully so that the creditors don't come after what would then be your separate share of the house if you divide it, or you're going to buy the other one out, or if you're the one, if the house with the business owner's spouse wants to file bankruptcy and the spouse who wants to stay in the house doesn't, there's a lot of complexity in that. True, Xue?
Yeah, it's complicated and it's individualized in how things are titled and what spouse wants what at what time. So it's important that you talk it out and that you really think about what's the best situation for both of you.
Thank you. Stay safe.